Good morning, good afternoon, good day from wherever you're joining us. Thanks for making the time to join Cliff Decker of Maya together with Udo Domapelo Sagie on this very timely issue of workplace harassment in Africa. My name is Kevin Kipchirchir. I'll be the moderator of this session. And we are joined by Phetheni Nkuna, who is a director in our Johannesburg office of Cliff Decker of Maya, and also Christine Mugenyu, who is a senior associate in our Kenya office of Cliff Decker of Maya. You will note that this webinar is also jointly presented by Udoma Bello Sagie of Nigeria, and we are joined by Victoria Amarachi, who is a senior associate in the Nigeria office of UUBO. Welcome all. And so just to give context a bit more on why we think this was timely to have this webinar today. Last year, CDH had hosted a global webinar actually on harassment in the workplace, and we thought it easier to zero in a bit more on what that means in the African context with the nuances afforded by Africa. And so today we are pleased to share, I think, on 3 key issues: what workplace harassment looks like in Africa, how to deal with it, and the steps that employers can take. And I think the key takeaway that we hope we will have from this webinar is what an employer, which I hope most of you are, can do, and the steps that they can take to ensure that workplace harassment does not occur. Just a few housekeeping, more or less on time. We will use the first 45 minutes on the round table, and we hope this session can be as interactive as possible. So please drop your questions in the chat box, and we will be able to answer them as we go along. And then there'll be a 15-minute session towards the end for an active live Q&A session where you will be able to raise your questions. But we can always start from somewhere. So first, let's define what workplace harassment is. Phetheni from the South. What does it look like in South Africa?
Thanks, Kevin, and good morning or good afternoon to everybody who's joined us. So just harassment, the definition of harassment, we draw from what we have in South Africa as the Code of Good Practice on the prevention and elimination of harassment in the workplace. It has been promulgated in terms of our Employment Equity Act, which broadly prohibits unfair discrimination on the basis of listed grounds in the Act in itself, or what was introduced by the judiciary a few years ago as an arbitrary ground. I will deal with those semantics a bit later. What the code has done is widened the definition of harassment. Previously, we had a code of good practice that dealt only with sexual harassment. But then we now have this new code, which has widened the definition of harassment to include sexual harassment as just one type of harassment, and not necessarily the only conduct or act that may arise in that instance. Now, the definition is unwanted or unwelcome conduct that impairs dignity, which creates a hostile or intimidating working environment and is related to one or more grounds as stipulated in the Employment Equity Act. There are a few key issues arising from these 3 elements of the definition. Firstly, unwanted, where the conduct is unwanted or unwelcome, has to be evaluated. You evaluate whether, firstly, the perpetrator knew or ought to have known that the conduct was unwanted or unacceptable. Now, the question of knowledge, obviously. So it can either be communicated. So, for example, if somebody taps me on my shoulder and I don't want that, I can communicate it. Either I say no verbally, or my body language, there's giving you some sense of expression. But then what the Code of Good Practice has done is cater for instances where it acknowledges essentially that people do not react the same. There isn't a set way of reaction. So somebody may consider the conduct unwelcome, but not communicate. Now, what the code has done is put this element to the definition that the perpetrator ought to have known that that type of conduct would be unacceptable. Sexual harassment, surely you ought to know that you cannot do that. So it considers that. It also sets what I believe is very useful, the parameters for evaluating the conduct. It's an objective assessment. It's viewed from a reasonable person's perspective. Obviously, not every form of conduct would necessarily be harassment. It could be a single or multiple acts. It's not necessary to establish or prove the intention or state of mind of the perpetrator. So your intention is actually not that relevant. Where it does become relevant is if you're found guilty, it can be used as an aggravating factor. Creating a hostile environment, this incorporates or takes into account a variety of issues, including negative impact on an employee's ability to do work, the impact of the conduct on their mental health, on their actual physical well-being. It can also, interestingly, the code says that harassment can also be indirect. So if, for example, you're not the primary target of the conduct, but the conduct in itself impairs on your dignity. So under the code, for example, it's defined racial harassment. So you may, for example, say something harassing against white employees. I may not be the I may not be the primary target, but if I'm a white employee and it impairs my dignity, I may very well have a valid claim of harassment. Then it also provides examples. Cyberbullying is a form of harassment, slander, ostracizing somebody, condescending gestures. So it's quite all encompassing and has been a very useful guideline.
Noted, Phetheni. And I think one of the key issues that we normally identify really is when we speak about harassment, our minds tend to tune to sexual harassment. So it's really good that you bring out that there's something more. Is that the same case in Nigeria, Victoria?
Yes, it is. Hello, everyone. Thank you for having me here. So yes, I would say, sexual harassment is indeed a form of harassment in Nigeria. I would, comment and probably say that we do not have any, like laws. There are no specific, labor laws in Nigeria that, define sexual harassment at the workplace. But what we do have is that we have our constitution that has conferred the Nigerian constitution that has conferred jurisdiction on the National Industrial Court to entertain matters of discrimination and, harassment at the workplace. Now, what the National Industrial Court had tried to do in its rules is to define sexual harassment at the workplace. It's in the rules, it has set out about 4 types of, sexual harassment, and, has stated that the physical conduct of things that would indicate that what the court has stated is that when a complaint is being lodged at the court, the complainant should be the complainant should state on the complaint what type of sexual harassment it is, whether it's one of a physical conduct, whether the sexual harassment is of a physical conduct, such as, like unwanted physical conduct, ranging from, like sexual assault or, any gestures that would constitute any alleged sexual harassment. Then there's the verbal form of sexual harassment, such as, suggestions, innuendos, sexual jokes, which or hints, insults or graphics about the person's body. Those are like verbal forms of sexual harassment. Then the non-verbal form of sexual harassment, which could include the unwelcome gestures, indecent exposure, sending of explicit pictures to one another. And then there is one key one, which is like the quid pro quo harassment, which is really what it is in the workplace, where an employer or a supervisor, owner of a business, or let's say member of management or co-employee, tries to influence the process of employment, promotion, something of economic value to an employee in exchange for sexual favors. So that's one key thing which the NSA had tried to introduce, which I don't think was, what we ever thought about it in that manner, but, has now or rather expanded the definition of harassment to include anything, or rather sexual harassment to include any harassment of where a person gets economic value in, person is saying, I would give you an economic value in exchange of, or in exchange of sexual favors. Yes.
Thank you, Victoria. And I think one of the key issues that I'm picking up is, so firstly, it need not be direct effects on the victim. And secondly, it has to be unwanted and uncalled for on the side of the employee or the employer in certain instances. Christine, is that the same case in Kenya?
Thank you, Kevin. Thank you for having me also. And just to acknowledge everyone who's joined us from Kenya, especially because of what is happening right now in our country. I've seen a comment from Alexa that you're with us in spirit. And so we appreciate all of you who have been able to join us on this webinar. So just listening to Phetheni and Victoria, the Kenyan position on harassment is leaning more towards what Nigeria also has, because in Kenya, we do not have a specific or a law against harassment in general. What we do have is we have guidance generally from the Constitution of Kenya in regards to each person has the right to inherent dignity as a human being. And as we know, harassment goes against this because it demeans someone, it makes someone feel less of a human being. And so drawing from this, what we do have in Kenya is a definition on sexual harassment in our Employment Act for 2007. So Section 6 of this Act basically provides that any employer who has more than 20 employees in their workforce, they should have a sexual harassment policy. And the Act makes it an offense for any employer who does have these 20 employees in their workforce and they do not have a policy. It makes it an offense for them, and they're liable. We actually do have cases which have gone to court where an employer has been penalized by the court up to the sum of Kenya shillings 50,000 for not having a policy to guide employees during on how to go about sexual harassment. But in terms of what constitutes sexual harassment, Phetheni and Victoria have explained that very well. It is unwelcome conduct. It is a conduct that is over sexual nature, and pointing especially to what Victoria said about the quid pro quo aspect of sexual harassment. That is exactly what is defined in the Employment Act. And also just to point out, the Employment Act in relation to sexual harassment gives guidance to employers on what is required in the policies that they should have in their workplaces. So, for example, you will see that the policy, of course, will have a statement basically giving the stand that the employer is against sexual harassment in any way or form in the workplace. And then the policy also should have what constitutes sexual harassment, so that then the employees are aware of what conduct can amount to sexual harassment. Then also, of course, the policy should also have the mechanisms within which an employer can go through to report, the reporting mechanisms, and also largely in terms of what the employees should do when it comes to sexual harassment. Thank you, Kevin.
Yes, thanks, Christine. And I think, dear listeners, you will note that now we are now speaking about employers' obligations. So I'd love to hear from Phetheni what now the process is and what is demanded of employers in the process of instances of harassment in the workplace, especially from an employer's perspective and to safeguard employees largely.
All right, so I will sum it up in 2 words: investigate and eliminate. The Employment Equity Act, Section 6. So let me start with Section 6, prohibits unfair discrimination, harassment being a form of discrimination under that particular piece of legislation. It then, in Section 60 of the very act, firstly, subsection 1 says that any breach of the act needs to be brought to the attention of the employer immediately. Now, our courts have recognized that what is immediate varies, because if it's racism, it could have gone on for over an extended period of time. If it's bullying, it could have happened over years, ostracization, victimization, etc. Likewise, sexual harassment, we react differently to something that demeans you or undermines your dignity. So, but there is that ask from a legislation perspective that bring it to the attention of the employer immediately. Obviously, it's always great to have to get or be informed timeously so that you're able to investigate, the perpetrator has not left the company, you're able to do something about it before things get out of hand. Now, once it's been brought to your attention as an employer, what the act says that you need to consult all the relevant parties and take the necessary steps to eliminate the alleged conduct. The consultation part would usually take the form of an investigation, finding out, firstly, consult with the complainant, what has happened, what would you like to do, and also advise the complainant of their options. They can either follow a formal or informal process. The informal process is usually for the less serious type of harassment. It can take two formats, where it could be the complainant and somebody else, usually that would be your HR person. They approach the perpetrator and inform the perpetrator that this conduct is unwelcome, you should not do it. The alternative to that would be somebody, it usually is HR, go to the perpetrator on an anonymous basis and say, this has been brought to the attention of the company, you shouldn't do that. So it offers protection where somebody is in that uncomfortable situation, but actually do not have the strength or the courage at that point to outright say, listen, don't do this. Then there's also the formal procedure, which is usually for the more serious type of harassment that can result in disciplinary action. Somebody could actually get dismissed for that. Importantly, an employer or an employee, the complainant, is not required to first follow the informal process before getting into the formal process. And the code also allows an employer, where an employee elects not to follow a formal process, the employer needs to conduct an assessment and see if there's any risk outside of the targeted employee of somebody being harassed. And if there is, then take formal steps. So just because I say, no, I don't want to take this further, does not necessarily mean it ends there. Then also what the code as well as the Employment Equity Act require is offering of assistance. Assistance could be maybe somebody needs counseling, somebody needs sick leave, especially in the unfortunate instances of sexual assault. Somebody could actually require to get medical attention, etc., etc. Offering them confidential advice. This is very important. It needs to be from somebody who's trusted, who's experienced. So if you designate somebody in the company to be the point of contact, they need to have the right skill, the right experience to deal with these type of issues. And then also, if you end up in a disciplinary inquiry, follow a fair procedure, because even if somebody is found guilty, if you haven't followed a fair procedure, there could be a compensation award, because you did not afford somebody a right to be heard and to answer the question and to answer to the allegations, rather. And then they eliminate the conduct. Elimination could take a variety of formats: training, education. It could be that people actually don't know the parameters. People don't understand what is harassment. I mean, the code speaks about passive aggressiveness as a form of harassment. It speaks about invisible treatment. So it's quite an all-encompassing piece of law that would need proper education and training on. Those are briefly the employer's obligations.
Yes, Phetheni, and I think we'll come back to your point on elimination when we discuss the good practices for employers. I just wanted to know from a practice, from an investigation perspective, and perhaps from Christine, how do employers deal with confidentiality concerns and the fair processes so that the employer is not sued by the perpetrator of harassment of, violating confidentiality in the workplace or unfair termination?
Thank you, Kevin. So confidentiality is a very, very important principle, especially during the investigations of a sexual harassment complaint. And what we have seen is that the courts do not take it lightly where an employer does not carry out the investigation and maintain the confidentiality of the victim and the alleged perpetrator. So what we have seen is that it is very important, even during the investigation process, that once the employer receives the complaint, the employer has an obligation to ensure the safety of the victim, which Phetheni has talked about, the immediate response and safety of the employee during the investigation, which for some it may look like changing the workstation or maybe sending the employee on leave to pave way for investigations. But it is very paramount for there to be confidentiality in the process. And with respect to the alleged perpetrator, as we know, since this is a complaint that must be investigated, the dignity also of the alleged perpetrator before being found liable after the process must also be maintained. So from a confidentiality perspective, it is paramount for employers to ensure that they maintain this during the process. Thank you, Kevin.
Thanks, Christine. Victoria, are there insights around the process and confidentiality in Nigeria? And perhaps we can come back to Christine and Phetheni on whether there is a special regime for the disciplinary process given the gravity of certain harassment claims. Victoria?
Okay, thank you, Kevin. So I would say that, as I earlier mentioned that there are no statutory legislations around this, but what we have seen in practice is that yes, indeed, an employer is required to keep confidences of such complaint, even where even as I said that there are no legislations around this, and then there really isn't. So I can't say that there's really a statutory process that the employer should follow, but in starting such investigation or whatever process the employer should do, we do have, if we do have to advise, we always, we probably recommend, depending on the gravity of the offense, we probably recommend that the alleged perpetrator, should probably be suspended administratively, where you have reserved such rights, to suspend an employee pending the outcome of the investigation process. Then interview persons who you need to interview, persons who are probably directly involved in the allegation. Keep confidences, because I know we once had, an incident where the company had, was supposedly doing an investigation, had not concluded an investigation, and then sent a firm-wide email to members of the company, letting them know the details of the allegation and, and every other thing. And it was really a big deal, because confidentiality issues and all, there were such issues around and all of that. Now, we know that the courts have made some pronouncements around, what the company should do, an employer's obligation in the event of such when such complaints or allegations are brought against another employee. And one key thing the court has always said is that the employer rather should always investigate. Now, I remember there's one foundational case, for such issues in Nigeria, which is that the AGK Maduka and Microsoft case, where the court held that there were no facts before the court showing that the employer had indeed investigated the issue, and the court was able to hold the employer liable for the alleged harassment claims against the employee. So though there are no laws around confidentiality and all of that, an employer would always recommend keep confidences, keep your processes confidential. Thank you.
Thank you, Victoria. And I think what I'm picking up is striking a balance between protecting the victim and adhering to the disciplinary processes that's been laid down in the laws, either out of practice or laid down in the laws, either in, for instance, Nigeria and South Africa, which has certain laws. So, and I see a question that has come up more timely in the chat section. Can an employer suspend the perpetrator while the investigation is ongoing? So perhaps, Christine, as you speak about the process largely, you can speak about this aspect. Then Phetheni.
Okay. Thank you, Kevin. So basically, as has been touched upon by Phetheni and Victoria, the major obligation for the employer is, of course, to investigate. And once investigations are complete and the alleged perpetrator is actually found that there might be a case against them, there is, of course, the process that must be followed as per the Employment Act. In Kenya, which gives the procedure to be followed. So for Kenya, of course, there is the notice to show cause that is normally issued to the employee. So in this case, it will include the allegations of sexual harassment or harassment in general, and then the employee will be given a chance to be able to respond to the same. And once they respond, if the response is not sufficient, then we move to the second stage of the disciplinary process, which is now the convening of the disciplinary hearing. So at the hearing, of course, the employee has a chance to respond to all the allegations again and also produce evidence that at that stage, the evidence that is against them is tabled, and then they are given a chance to respond to the same. And then after that, then we have deliberations on the representations made by the employee, and the employer now makes a decision on what sanction to take against the employee. And so if the policies of the employer allow for the suspension of the employee, then the alleged perpetrator is to be suspended during the investigations or to pave way for the investigations. Because as we said, the employer's obligation is to maintain the safety of the victim and also to ensure that the workplace is safe, because harassment can be a continuing injury. So it is very important for an employer to take these measures at that stage. Thank you, Kevin.
Thanks, Christine. And perhaps before Phetheni, you come in, there are two questions which I think you might tune your answer to. What happens where the victim does not want to participate in the disciplinary process? And I think we've seen this in Kenya, Christine. And where there are questions as to the truthfulness of the victim.
Okay.
Can you?
Yes, thank you, Kevin. So what happens is that during the investigation process, this is when the employer must ascertain the truthfulness of these statements. And what we have seen is sometimes employers engage third parties who have the requisite expertise to do the questioning, to do the fact finding, to carry out the investigations, for them to be able to ascertain whether the complaint is actually is what happened and is truthful. So in terms of how to deal with that, an employer can always engage a third party to be able to assist in also having knowing whether what happened actually happened. Yes, and then the second question is that if the best approach if the victim does not wish to partake in the disciplinary inquiry related to the harassment. So yes, we have had anonymous complaints, and what we have seen is that an employer's obligation does not end even when a victim wants to remain anonymous. An employer must still go ahead to take disciplinary action and table these complaints to the alleged perpetrator and proceed with the process, even where the victim remains anonymous. Thank you, Kevin.
Thanks, Christine. Phetheni?
I think let me start off by just again highlighting an employee's obligation. So under the South African legislative regime, we've got the Occupational Health and Safety Act, which obliges employers to ensure a healthy and safe working environment for all employees. So this is one of those critical pieces of legislation which feeds into what in fact happens when you've got harassment in the workplace. It threatens safety, it threatens health. We talk about mental health. In more serious cases, physical health is also affected. Now, an employer has obligations stemming from that piece of legislation. Drawing into the Employment Equity Act, what the Act says that is an employer must consult and take the necessary steps to prevent or eliminate the harassment. That could take a variety of forms. Importantly, under Section 60, subsection 3, the Employment Equity Act says that if an employer fails to take the necessary steps and it is proved that harassment had indeed taken place, the employer will be deemed or must be deemed to have also contravened that provision. So what this means is, if as an employer you fail to take steps, firstly, it's not just steps to deal with the complaint, but steps to ensure a healthy and safe working environment by having policies in place, irrespective of the number of employees you have in your organization, you need to have policies in place. In fact, when the question is considered whether or not you complied with the obligation under Section 60, one of the questions that will be asked is, did you have policies in place? If you did not, you in fact participated in the harassment. So you will be held vicariously liable. And we've seen this play out. I mean, a few years ago, this was just 2 years ago, an employer, there was a 3.9 million rand award in damages because an employer had not had the right frameworks or mechanisms in place. And to make it worse, did not do anything when an employee was harassed for a very prolonged period, and this was sexual harassment. So there was a 3.9 million rand. So the damages can actually be exorbitant, and you will be held liable if you fail to do what you have to do as an employer. Now, feeding into the questions that you've just posed, we do not have a special regime in South Africa. Misconduct is misconduct. It will be dealt with as misconduct. Usually what would happen in this instance is you would have a complaint, preferably investigate. That in fact is provided for under the Labor Relations Act, Code of Good Practice on dismissals. Investigate the veracity of the allegations before you go into a disciplinary inquiry. If the investigation, so an investigation does not necessarily have to be formal, it's really a fact-finding process. If you determine that the allegations are credible, you haven't made a finding on whether a person has in fact perpetrated harassment. But if you believe on the facts that you've gathered, there is a case to be answered, then you call for a disciplinary inquiry where the perpetrator you will put the allegations to the perpetrator. They will have an opportunity to respond, and responding is them testifying, bringing forward whatever witnesses they have, and then preferably before an independent chairperson. It always has to be before an independent chairperson. What we've seen clients prefer within our jurisdiction is have someone external to the organization. So that could be a counsel. I've also chaired such processes. So create that separation so that a person is impartial. There's a bit of distance between them and the organization. And once the process has been concluded, there will then be a finding. They'll be afforded an opportunity to make submissions on mitigation and aggravation, and then an appropriate sanction will then be handed down. Again, importantly, your policies need to set out a guideline on what sanctions may be meted out if a person is found guilty of harassment. Now, on the question of anonymity and somebody not wanting to participate, that makes it a bit complex, because whilst the standard of proof in South Africa for these type of acts is on a balance of probabilities, you need evidence. And if the victim says, no, I don't want to be part of this, then you will obviously have difficulty in establishing the misconduct before a disciplinary inquiry, because you don't have the direct evidence. It may happen in those exceptional circumstances that there were witnesses to this act who may be called to come and testify. Again, the code says that a complaint does not necessarily have to be brought up by the targeted employee. It could be by anyone, a union rep, somebody in HR. So if you do have that, then you will call for that. But again, it's also important to remember that employees owe their employers a duty of good faith to act in the best interest of their employers. Dealing or helping an employer deal, first bring it to the attention of the employer and helping them deal, which is part of elimination or prevention of harassment, is you acting in the best interest of your employer. So there are questions around that. Have you fulfilled the fiduciary duty that you owe to your employer to act in their best interest and to ensure that their interests are not harmed? So yes, that's it from a South African perspective.
Thank you, Phetheni. And I think what sums it up, and if I may analogize this justice principle, is justice must not only be done, but must also be seen to be done. So employers must prove, and that's the next part, which I think would be most exciting to our listeners, the best practices for employers in relation to these concepts of harassment that we are discussing. What should they do? Risk mitigation measures. And I think, Victoria, you want to have a go?
Yes, thank you, Kevin. So my first word will probably have a policy. Now, you can mitigate a risk where you do not have policies around how to mitigate this risk. Yes, it's a risk, but yes, it can be mitigated. Now, the concern usually is, an employer has to, it's not the concern that, so an employer has the obligation to provide a safe workplace for, its employees. And then where such issues of harassment happen, it opens, it exposes the company to liability. But once there's a policy, the company knows what to do at every point in time. The company is aware, of how to go about, any harassment claims against it, right? And then, these policies will probably contain on, reporting mechanisms, what the company should do at every point in time, include issues of what happens where the perpetrator is high up in in cadre of employment, and really just the policy just states how to lodge a complaint and everything. Now, the concern that usually arises is the liability that the company would be exposed to if they fall into any of these issues. Now, what we did notice in a particular case, a review of a particular case, was that the company was held liable for having breached an employee's fundamental human rights. The court held that that the sexual harassment suffered by a claimant, so in this particular case, she had suffered sexual harassment, and the court held that that sexual harassment suffered by the claimant was an affront to her dignity of person and a breach of the Constitution. So and that the company did not comply with its harassment policy. Now, it still brings us back to comply with your policy. Now, what we have noticed is that in complying with the policy, there are several pitfalls that employers seem to fall into, which would include issues around disciplinary procedures in the event of you finally investigate and you find someone culpable. Now, what our laws require you to do is that you follow your disciplinary procedure. This could include, issuing a query. When you issue the query, you call for a disciplinary hearing. Now, when you call for a disciplinary hearing, several times we've seen employers not give fair hearing, because usually the concern is fair hearing. Now, when an employee is not giving fair hearing during this process, there are usually concerns, and that also exposes the company to such risk, right? Now, the principles of fair hearing, which our courts have held over time, includes the employee being present through proceedings and to hear all allegations against it. So it's not enough that your investigation has found a prima facie case against an employee. You still need to accord that employee a fair hearing. the employee should be allowed to, cross-examine the victim, who has or contradict this victim, because yes, the victim has said, stated all of that, I was harassed or, or sexually harassed even, and then they should be allowed to contradict this victim. They should be allowed to cross-examine. Then they should be aware of, before the disciplinary hearing, they should be given adequate notice of the disciplinary hearing. Then they should be allowed to give evidence by them, allowed to give evidence or call witnesses if that's what they want to. But basically, what the court wants to see is that you have actually complied with all the principles of fair hearing. That helps you mitigate any risk that may arise in the event that any employee decides that they want to sue you for any alleged breach. And so you've mitigated your risk where you have complied with all these principles, as I have just mentioned, and then being mindful to comply with any existing policy, because you really can't deviate from any of these policies without without the consent of the employee. Since both of you have agreed to this, so both of you you can't deviate really. You really have to just comply with your policy, and you must be seen to implement it, and there should be no bias in implementing it. Now, one thing I did realize, in having to read up on cases on several of this, is that the decision should, there should be no bias. Now, so I'll probably take us to a case where the employee was terminated even after she had, alleged that she was harassed by her supervisor. Now, what had happened was that she was transferred out of state, and then she was asked to report to the junior officer. Now, in all of this, when the company did investigate this issue, they arrived at the fact that though she had tendered evidence that she was being sexually harassed by her supervisor, what the company arrived at in arriving at a conclusion at the end of the investigation was that the employee that's the perpetrator, the alleged perpetrator, should take leadership trainings. Now, the court held that there was definitely a bias from the outcome of that investigation or disciplinary process, and as such, it couldn't hold waters, before the court. So the company didn't manage, or rather didn't go through the process as it should have, or comply with its policy as it was expected to, and as such expose itself to risk. So, so my parting word would be probably have a policy, comply with your policy.
Excellent, Victoria. Thank you very much. So Christine, and I want to quite tie your hands a bit by limiting your response to the following two nuances: that often harassment happens behind closed doors, and often employers that we deal with will have outsourced their employees. How can employers mitigate their risk in such circumstances?
Thank you, Kevin. So, like we have said, this harassment and sexual harassment in general is a very sensitive topic, and it's a very sensitive area. But in line with what we have discussed, is that every employer does have an obligation. Even when we have outsourcing of employees, they have an obligation to ensure that where the employees are working in the course of their employment, that they are safe and the environment is also healthy, and they are not exposed to any form of harassment. So the obligations to ensure their safety and that they are protected from harassment still exist, even where the employees are outsourced, and so the employer's obligations still continue even in that respect. And I think just to add to what Victoria was saying about how to mitigate the risk, there is also the employers should ensure that even their employees are aware of these policies and are aware of what to do in case of they encounter this harassment, because we found instances where employees are not aware of these policies. They don't know what to do. They don't know the reporting channels of the company, and so we find that it is very important for sensitization to continue to the employees employees for them to be aware of what to do in these instances. And then I think also an additional point that we might not forget is the leadership of these companies, the management, because as we say, a workplace is only as good as the culture. It is the top management. Are they committed to ensuring elimination of all types of harassment? So if they do this, then the employers, of course, mitigate the risk of harassment and being found liable by the courts.
Thank you, Christine. Phetheni, I'd like to just attune, and I think you had mentioned a while back that there's a company in South Africa which was fined 3.9 million rand for failing to have good practices among itself. So speak to us from a practice perspective. What have you seen in the South African labor market? How does it look like? And secondly, from a procedural angle, what are the risk mitigation measures that can be put forth?
All right. So the variety of pieces of legislation and the codes of good practice really bear testament of how serious the issue of harassment is, because it's a barrier to equity in the workplace. I mean, let's take, for example, somebody who suffers what's termed sexual harassment victimization. You can't be promoted because you refuse to give in to sexual favors. Or the reverse, where somebody experiences sexual harassment favoritism, they're getting ahead not based on merit, but because they're sleeping with somebody. And that prejudices worthy candidates who are actually very competent and would be suitably qualified for those positions. So those are some of the things that really show how serious harassment is taken within the South African market. The impact on well-being, mental health, physical health. So we see that it's also translated into how our courts are dealing with harassment. It's coming up. There's a plethora of judgments that we've had where judges, the courts are sending out a stern message that this is horrendous. It's a heinous crime. I mean, it's been referred to as a crime. That's how serious it is. And there've been cost orders, damages awarded in favor of harassed employees, just to send the message that employer, you need to take your obligations seriously, have policies in place, educate, communicate those policies. As a firm, we've even developed a tool that we actually sell to our clients. We market to our clients. It's called the harassment e-learning tool. So instead of somebody physically sit there, we've used AI, we've leveraged technology to develop this very useful tool that clients can deploy and employees can engage with it. You know, it's very interactive. You get it's training on the move. It's easy, it's convenient. You get it wherever you are. So those are some of the things that you need to bring in. Do you have the right tools? Are you leveraging what you should? And again, goes to what seems to be common across the various jurisdictions. When a complaint is brought forward, investigate and deal with it. Yes, there are instances where a complaint is vague and you don't have much to go on, but at least investigate. And if you determine that you don't have sufficient facts to warrant further action, close it out, but certainly investigate it. And again, if you don't do anything about it, there will be consequences. I've already dealt with the procedure. It just occurred to me as you were asking Christine the question, it does happen that it's harassment not perpetrated by another employee. Somebody is being harassed by a member of the public. Somebody works, I don't know, a retail client. If you've got somebody placed to man a store at a mall and they're being harassed, what options, what protections are available? Firstly, the Code of Good Practice obliges employers to conduct a risk assessment. So that is really getting insights into what are the risks of somebody being harassed whilst they're performing their job. If you have people who go out into the field to render a service, to do whatever, what are the risks? Do you have the right mechanisms in place? Are they able to reach a supervisor if something goes wrong? Do you have mechanisms that enable you to reach them if somebody in those unfortunate instances, somebody attempts sexual assault, what are your response mechanisms? How do you check in? WhatsApp groups, how do you check in with people who are in the field? There are various things that you can put in place, but you certainly should conduct, at least in our context, you need a risk assessment, because if something goes wrong, that's one of the questions that will be asked. Did you do a risk assessment? And what were the risks that you identified? What did you do to deal with them? But over and above that, if harassment occurs outside of the employer's control, we have a variety of legislation that covers that. For example, PEPUDA, Promotion of Equality and Prevention of Unfair Discrimination. It enables you to get a restraining order. It provides for the establishment of the Equality Court. We've got the Protection from Harassment Act, which again protects. It works both ways. If harassment is perpetrated by your employer against your employee against a non-employee, again, the reverse. It provides protections, it deals with that. So we've been fortunate to have multiple pieces of legislation that work together within and outside of the workplace to regulate and to also provide recourse where somebody is being harassed.
Thank you, Phetheni. And I think that summarizes our roundtable. But only one question for you, Phetheni, and I think Victoria and Christine, you can chip in. Are there any remedial obligations for the victim other than the disciplinary process being meted out on the perpetrator?
On the victim. So you can lean on the various pieces of legislation that I've mentioned. The PEPUDA, which provides for the Equality Court, it can issue out a multiple of orders, for example, ordering somebody to apologize. It can direct payment of damages to the victim. It can issue a restraining order. You have the Protection from Harassment Act. Under that piece of legislation, you can get a protection order. We've got Protected Disclosures Act, which really is intended to protect whistleblowers. So if you're a whistleblower, you're whistleblowing on harassment, it offers you protection against occupational detriment, which is victimization or retaliation because you've blown the whistle on something. So we do have that legislative framework that provides protection outside of what the employer can do. Obviously, you can lodge a criminal case where, for example, sexual assault is a criminal offense. You could get somebody criminally charged. So there is a variety. Again, I suppose it stresses the importance of advice and assistance, because when you're a victim, you need to fully understand what options are available to you, what protections are available to you. But certainly, I would implore employers to have the right people with the right skills and experience in place to deal with this component, because it becomes very critical when somebody is a victim of harassment. They need to understand the full scope of their rights and protections in law.
Thank you, Phetheni. And I think we could go on and on about harassment in the workplace. It's diverse, and the law keeps evolving to include more and more forms, I think, as the workplace evolves as well. So I think we see instances where we could have sexual harassment as well as bullying, victimization, ostracization as part of the charges that could be leveraged against a perpetrator in the context of harassment. So now, before we dive into the Q&A session for the last minutes of the webinar, I've dropped a link to the CDH tool, the CDH Africa Harassment Guideline, developed with our network of law firms across Africa, that should be able to guide you, ladies and gentlemen, as you navigate employment and harassment in the workplace. We hope this tool will be helpful together with this webinar. So just to go through the chat box, and now you can drop your questions as you sum up what has been discussed in the webinar. The first question to you, Christine, would be, how do you weigh testimonial evidence? Because it could be a he said, she said sort of thing. How do you weigh that?
Thank you, Kevin. So I think the first part is just to highlight that when we are dealing with disciplinary cases that involve employees, the standard of proof is on a balance of probabilities. So it is not like in criminal cases where we have beyond reasonable doubt. It is basically where if this evidence is presented before anyone or any reasonable man, would they come to the conclusion that there was probable harassment. So like we have said, there would be challenges where, of course, there is anonymity. The victim wants to remain anonymous, but the obligation on the employer is to take action, to investigate. Then once they have the evidence before them, then they make an assessment of the evidence, and if it is sufficient evidence, then present it now to now the formal disciplinary process. Because what we have seen is that at the stage of the assessment of the complaint or the evidence before, we have seen instances where employers don't have much to go on. And at that instance, then there is no need for there to proceed to a disciplinary process. The complaint can be dealt with at that stage. Thank you, Kevin.
Thank you. And Victoria, in Nigeria, have you seen instances where due to the anonymous complaint, the perpetrator takes an employer to court for unfair termination because they were not given the opportunity to cross-examine the victim in the context of anonymous complaints?
So I'm wondering how that will work in the context of anonymous complaint, given that, anonymous, you do not know who this person would be. But, one case that, comes to mind, which we had to handle was where there was an anonymous complaint and the company had to, investigate, or rather, ask the victim to come forward, and then the victim refused to come forward. And then so what had happened was that the company then investigated, discreetly, and then realized that, the person who the victim, had alleged had, harassed her, or, had complained about in the anonymous complaint was actually, like a known perpetrator. So there were several victims who came up, and then the reason why they had not come up during the, when the issue had happened was that they were concerned about retaliation given the person's position in the company. So what had happened was the company did investigate, closed out that process. And what they did afterwards was to do a reorientation for employees, letting them know this is the policy, this is what the company would do in every instance, this is how we would always manage such, just to give the employees confidence in the system, really, because at least the employees could see that the company had taken action regarding the perpetrator, even though it had stemmed from an anonymous complaint. So, in anonymous, there really wouldn't be any cross-examination, but yeah, this is how we would recommend that the company should go along, in such an anonymous issue.
Okay, thank you, Victoria. I note the link might not be working for some of our members. I've now requested for another link. It will be circulated shortly. So I'm not just thinking where an employer does not meet the threshold. For instance, in Kenya, Christine, an employer with more than 20 employees is required to have a policy where the employer does not meet. So, for instance, a startup with, say, 15 employees, and yet there are consistent occurrences of harassment in the workplace. Are there any risks that lie to them, or should we be telling our employers, just have a policy as good practice, regardless of the number of employees you have?
So you can hear me now? Okay.
Yes.
So yes, the law does put an obligation on employers who have more than 20 employees to have a policy, but it is best practice, and we advise all our employees and all our clients to have these policies in place, because you see, just because you have, I don't know what the rationale was for just having 20 or more employees, just for them to have a sexual harassment policy, because it can happen even when there are 2 or 3 employees. So I think from a best practice point of view, it is best for employers, as long as you have employees, you should have a policy in place to guide employees to know what to do in cases of sexual harassment or any other form of harassment.
Thank you, Christine. So I think we've covered all the questions in the Q&A box. So perhaps parting shots from each of our panelists, Phetheni, and then we can wrap this up.
Perhaps as a parting shot, I should address the question that was asked by Keshni. You'll forgive me if I didn't pronounce your name correctly. The question is, during the disciplinary process, can the charge sheet include separate charges under the umbrella of harassment, such as bullying as a charge, victimization as a charge, etc., or should it be a single charge of harassment? So within the South African context, but I assume it would work similarly across various jurisdictions, splitting of charges is not allowed. So you could, for example, make an election, either couch it as harassment and then have subtopics which set out the various incidents of harassment. If you're dealing with a bullying incident, you're dealing with the abuse or selective use of disciplinary process, but certainly don't split the charges. Alternatively, which in itself could be confusing, is be precise. Charge one. It is alleged that you bullied XYZ during the period it's X. Charge two, it is alleged that on whatever date you pressurized an employee to resign, because that is a form of harassment. So be clear. So you could make an election, but then again, the standard in South Africa is disciplinary processes are not criminal proceedings. There's a bit of flexibility, but we need diligence in how we draft charges. Yes, whilst the standard is very relaxed, not necessarily as strict as it would be in other jurisdictions, be coherent, be precise. If you're going to charge somebody for harassment, then you need to clearly articulate the specific instances of harassment that you're charging this person for. And if you're not using the umbrella harassment, then say charge one, abuse XYZ. Charge two, sabotage, in that you did XYZ. So you could deal with it on that basis. But to wrap it up, we could go on and on about harassment. We do welcome that our legislation is evolving. Our courts, the judiciary are actively looking at this and sending a very stern message out there to both employers and employees who engage in this type of commitment. But overall, let us uphold the law. Let us ensure that our employees are safe and healthy. There are benefits. There are countless benefits to that. Improved productivity, great culture. Some of those things are achieved because you have the right mechanisms in place and you actually take action where instances of harassment arise. That's it from my side.
Victoria, maybe in 30 seconds.
Thank you. Thank you, Kevin. So as a parting word, I would say that, even though we've mentioned that, we have mentioned that, companies should have, policies in place, harassment policy, just so that you know what to do. I should mention from the Nigerian standpoint that in 2022, Nigeria ratified the ILO Violence and Harassment Convention 2019. And one of the key things that the convention says is to have a policy. So irrespective of, no less specific legislations around harassment policies, we have this convention which was recently ratified by Nigeria, and employers should do well to have this policy. And other than even having a policy, one key thing we can take away from here is that have a policy and then monitor the implementation of the policy. Evaluate your policy constantly, just so that you're aware, you know the gaps in the policy, you audit your process constantly, and you eliminate any concerns about retaliation in the workplace. Thank you.
Christine?
Thank you, Kevin. I think from a Kenyan perspective is just to urge employers to take a proactive and a preventative approach towards harassment and sexual harassment in particular, because we have seen, while we don't have a specific a law that addresses harassment as an issue, just like South Africa, what we have seen is that our courts have have come out with so many pronouncements on how to deal with harassment, and they are very, very strict on employers who do not take a proactive approach when dealing with harassment in their places of work. So it is very important for employers to continue employing this best practices in their workplaces to ensure that they mitigate the risks that come about from not being compliant with the law. Thank you, Kevin.
Okay, ladies and gentlemen, we've come to the end of our webinar on workplace harassment in Africa, especially obligations of an employer. We want to thank you for making the time. We have developed a guideline, and we note that the link we circulated may not be working for some of us. We will circulate it together with the recording for this webinar. And Shireen, really sorry that the meeting request was for 12 p.m. Central African time, which should be 1 hour ago, but we will circulate the recording nonetheless to everyone together with our guideline. Special thanks to Christine Mugenyu, Victoria Agomuo, and Phetheni Nkuna, the very good ladies who made the time to speak to us this afternoon. It's been lovely hearing from you, and it's been so insightful. Thank you, everyone. My name is Kevin Kipchirchir, and I've been your moderator this afternoon. Goodbye.
Goodbye. Thank you, everyone.
Thank you, everyone. Goodbye.